All right, so now that we are recording, let the minutes for this meeting properly reflect that there was a roll call. All commissioners in attendance with the exception of Commissioner McMillan. Commissioners McMillan and Bluestone having been appointed to new terms by their appointing authorities, have properly executed their oaths of office with the Secretary of State's office they now sit, which brings us to the next matter, which is the approval of the agenda. We have some modifications to it. As the agenda is sitting there will also be an additional bit of information early on, a legislative update from Jeremy, and mostly in the executive session due to, well, for a variety of reasons, there will be some matters that will not be, nothing will be added, but some things will be subtracted from there, which I don't think I need to go into.
Chair, I could frame up a motion and ask a commissioner to make it if you like.
Yeah, okay, let's do it that way. If you think that's better, that's fine. I'll defer to you.
Okay, so commissioners, on items 8 and 11, which is the only Relona matter for this meeting, requesting that those items be removed from the agenda for today. Becky indicated that she'd like to do a little bit more investigation on another point that has arisen in that matter, and so we'd like to take that off today's agenda. On items 9D and E and items 12D and E, Commissioner Villanueva has recused from those administrative matters, and because Dr. McMillan is not present, we don't have a quorum for those matters. And so I'm asking that they be removed from the agenda and held over for the next meeting when Dr. McMillan can attend and there can be a quorum. And then commissioners, Commissioner Bluestone has recused from items 7A and 9A and 12A. And given that, we'd request that we do the administrative complaints first in executive session, allowing Commissioner Bluestone an opportunity to recuse from the discussion of item 7A. And to further complicate this, administrative complaint 2023-06, which is item 9A, is related to item 7A. And so we'd ask that item 9A be put at the end of that list of administrative matters, allowing Commissioner Bluestone an opportunity to recuse from the discussion of that matter. And also, as the chair mentioned, I'd like to add an item before the advisory opinions just to provide you with some legislative update.
All right, does anyone want to adopt Jeremy's comments as a motion?
So moved. Second.
Second. Is there a second?
I'll second it.
Thank you. It's been moved and seconded. Any discussion?
Yes, I would like to also amend the motion, which I think is a friendly amendment, to add before we go into executive session, an update on the Financial Disclosure Act investigations of the late filed financial disclosure statements, so that we can get Jeremy to explain that. And if any of it needs to go into executive session, I'll defer to him, but I would like to have an open public discussion of what we agreed at the last session would be our strategy.
Okay, Jeff, you moved. Do you accept the amendment?
Yes, I do.
And Celia, I believe you were the second. Do you?
Yes, it's fine.
Okay, so the amended motion and second or before us, is there any discussion? Okay, hearing none, the agenda is modified as stated. Now that it has expired from my iPad, I will go to said agenda. The meeting minutes from the June 2nd meeting in Las Cruces were provided to everyone. We've all had a chance to look at them. Is there a motion and a second to approve the minutes from that meeting?
So moved, Mr. Chairman.
Second,
Thanks. It's been moved and seconded. Any discussion? Hearing none, the motion to approve the minutes of the June 2nd meeting is carried. On to item number 5, which is, no, first, Jeremy, let's go with the amendment, your legislative update, I'll call it.
Sure, thank you, Chair. So Commissioners, I wanted to tell you about a phone call I received last evening. I was in the office and a member of the Senate called me and we talked for a while about the challenges from the past legislative session and ideas to how to remedy some of the challenges we experienced in the last session. But the senator also, he told a parable that that I took as a very great compliment to the commission. And you've probably heard the parable before. It's one that I believe I've heard at a funeral before, but it's about this this battleship, this captain of this battleship late at night and sees another light in the distance and radios to the other vessel, you know, this is the captain of the battleship and you need to divert 5 degrees to the west. And the light radios back, no, you need to divert 15 degrees to the east. And the captain goes and it's like, well, we got a smart aleck here. We need to go and I'm gonna go get the admiral. And the admiral comes on and says, I'm the admiral of this battleship and I'm telling you, you need to divert 5 degrees to the west. And the radio comes back, well, I'm a lighthouse and you need to divert 50 to the east. And the senator said, you know, you, the commission, you all are the lighthouse. And it wasn't, the point of the parable is not about what would happen if there's a collision between the ship and the lighthouse. The point of the parable is that the ships, they see other ships. That's what they're naturally inclined to see. Out the other lights out there in the darkness are other ships navigating the political waters, promoting their certain policy goals and their political interests. And the senator said, what you guys are not that. You're the lighthouse. And that was a very great compliment that I wanted to pass along. Because our experiences of the legislature over the past 4 years involves being mistaken for a ship when in fact we're not. So with that, there's a few legislative updates. The first is I wanted to let you know that I've reached out to both Senators Worth and Baca and requested meetings with each of them just to discuss the commission's work and the value of the commission. These aren't urgent meetings. They're not about any specific legislation. And I'm very much hoping that I can find some time with each of those gentlemen later in the summer or in the fall. I've invited Dr. McMillan, or I included him on the email to Senator Baca's staff member on the off chance that's something he'd be interested in. And so that's kind of where I'd like to try to mend some of the fences that that were trampled during the session with respect to the Senate in particular. And then also by way of legislative updates, Wendy and I are now working on ideas for the FY25 appropriation request. And we met with our LFC analysts that are assigned to the commission, the outgoing one and the incoming one yesterday, and pitched the idea of another addition to the commission's personnel, another position for an attorney one position, a baby attorney position. And the idea is for the past 4 summers, I believe, we've operated a very successful summer associate program. And it would be wonderful if the commission could recruit out of its summer associate class 4 new attorneys. The law firm that I worked in Atlanta had a policy for never hiring lateral associates, and that led to a very close-knit culture. And while that's not replicable here, I believe the commission's ability to hire out of its summer associate class would be a very, very good idea. And the LFC analysts seem very enthusiastic about that. And so Wendy has some ideas around how to create classified positions for that. And so we discussed that, and then we also discussed natural increases that we're seeing in our 400s category related to our lease and our the costs of doing the business that we do with our search engines and our different services, our do-it costs. And so the way that I'm envisioning the FY25 appropriation request is for an additional personnel, which is a baby attorney position. It'd be a classified position because that's the remainder of all of our positions will be classified positions until there's another division in this agency. And increases along the 400s that correspond to what we can show in terms of cost increases. And so that's where we are, Erlang, by way of what's going on vis-a-vis the legislature at the moment.
Thanks. Does anybody have any questions on those matters?
I'd like to make a comment. First of all, I just want to commend you, Jeremy, for reaching out from Baca. But I would also recommend that you do the same for the Speaker of the House and his staff, and for the Minority Leader of the House and his staff.
That's well taken.
And I'd be happy to
Right.
meet, as you've extended to Dr. McMillan with Senator Baca's meeting. I'd be happy to do the same with Speaker Martinez and his staff.
Well, then we'll do that. I'll send an email and CC you, and we'll try to find some time on the speaker's calendar.
Okay, good. Thank you.
Thank you. Anyone else? Okay, then the next agenda item by my count is number 5, an advisory opinion number 2023-05. Jeremy?
Well, Chair, Commissioner Bluestone had added the financial disclosure update.
I'm sorry. I got lost in all those notes, and my apologies for that. Okay, go ahead with that Financial Disclosure Act update.
Okay, I'll provide a retrospective up to a certain point, and then I'm going to ask Casey to provide kind of an overview of where we are in the moment, and some of the challenges that she in particular is experiencing in this work. After the last meeting, after the commission authorized demand letters, same with last year, recommending before that a letter to the governor, and authorized civil actions to enforce the Financial Disclosure Act. After that, I sent a letter to the governor via her chief of staff, with copies to the Secretary of State's office, to the governor's general counsel, to the directors of each of the boards and commissioners, for those board members and commissioners who were remiss in filing and who, given their positions, really ought to file. After I sent that letter out, I began to work on ideas for a press strategy related to that. Larry Barker, who is an investigative reporter with KRQE, coincidentally emailed me and asked for an interview, or called me and asked for an interview related to a story he had been working on over time related to the Financial Disclosure Act. And I sat with an interview with Mr. Barker. he asked me to delay the issuance of a press release related to what we had done so far until his story could run. That was in June. At that time, I was under the impression that the story would have run by now. And I've been in contact with him, and he said that they're writing it, and it would appear in the near future, and he would keep me updated. So there hasn't been a press release related to the letter to the governor. And it's not only because of the representation I made to Mr. Barker. As the commission knows, we have business with the governor's office at the moment. And I can tell you that the relationship with the governor's office at this moment is very, very tense. And I didn't think it would be in the best interest of the agency to issue a press release based on the letter to the governor, given that tension and given that effort. And so that's where we are on press. Since the letter to the governor indicated the time at which we would begin to send demand letters, individualized demand letters to the various targets. And I'll turn it over to KC to give an update of those demand letters going out and kind of where we are with respect to each of the individuals that we're targeting.
Commissioners and Chair, let me see, we sent out a number of demand letters following the letter to the governor's office. I believe only 1 or 2 individuals filed after that initial letter went out. This is sort of the first wave. This is individuals who we've determined are either state agency heads or members of really the most sort of significant boards and commissions who've not filed their 2023 disclosure statements. At this point, about half of them have filed. But one of the things that I am getting in response are people who are really struggling with CFIS. I think, as all of you are aware, there's some difficulties with the system. And so part of what we're dealing with is individuals who think they've already filed, members of their agency who are telling me that they filed on behalf of the individual. And I haven't received anything yet showing something was filed and then isn't showing up on the CFIS system, but it is something that we're navigating, whether or not the issue is the individual hasn't completed the filing or if it's simply not showing up on the CFIS system. And so that's another difficulty that we're having, because if we have an individual who's telling us that they've already filed, even if it's not showing up on the Secretary of State's website, it's going to be very difficult for us to proceed with litigation without a clear answer, sort of one way or the other, as to whether or not they've actually filed. And so that's what we're navigating right now. They still have a couple of weeks to come into compliance before we really need to take that next step. And so that's where we're at.
So let me wrap up. Thanks, Casey. With we're in the midst of this. We are going to do press as the commission instructed. But we are not at a point where we even know what the results are, given the challenges because we don't know, in fact, who has filed and who hasn't. And given the uncertainty with CFIS, until and unless we can resolve that, that's going to present an obstacle for what we do in terms of enforcement action. If we can't reliably confirm that individuals have filed or not have filed when they say they have filed, that puts us in a very difficult position to actually enforce this statute. So that is something we are going to speak with the Secretary of State's office about at our next meeting.
If I might, all of you know that I am technologically challenged. And when it came time for me to file my financial statement, I needed the assistance of Casey, Jessica, and Suha in order to get it done. And I just wonder, because so many people evidently are having difficulty with the situation, with the system, is it possible to have folks whose financial disclosures are not yet being recorded as being received, that they just do it on paper and submit it that way? Is that acceptable to, does that fulfill the legal obligation?
So, Chair and Commissioner Baker, it would if there were a process for that. I mean, I do not believe the Financial Disclosure Act requires electronic filing through the CFA system to comply with the legislature's instructions. But the only process that I know of at the Secretary of State's office is the CFA system. I'm not aware that they have a backup, less technologically complicated system, just a piece of paper that you fill out. And you know, part of what I think needs to be done in the Financial Disclosure Act space is both have a statute and a system that is far more administrable than it is, and less techy, less technologically complicated. I mean, Congress relies essentially on an Excel spreadsheet, and you know, that's an idea that I think is turn to. But right now, in response to your question, I'm not aware that there's even a form apart from the CFIS web form system that the Secretary of State's office uses.
Yeah, I would point out also that, I mean, for such a simple operation, whoever designed that on behalf of or sold it to the Secretary of State's office, it is the ultimate, what time is it? Here, I'll tell you how to build a watch conundrum. It is diabolically confusing for such a simple proposition. So it seems to me that the first thing to do would be to have them talk to their vendor and get it fixed so that we don't have this next year. We have an interest in seeing that happen, and I would suggest being more rather than less forceful about it if we're the ones that are supposed to deal with the outcome. And secondarily, if you go to a no cash system, then you're stuck with a credit card machine breaking. That's kind of what they've got at the Secretary of State's office. You know, it would be probably a page and a half at most of paper for somebody to figure out. And we're not talking about millions of people. So I would encourage them to figure out somehow to make it work, because, or have their vendor do it, because ostensibly it's just a simple operation that has been turned into three-dimensional chess for no apparent reason other than just technological incompetence on the part of the vendor. Anybody, Stuart?
Thank you, Mr. Chairman. I have a few questions first before a comment. First of all, my recollection is at the last meeting, we were told that there were something like 109 late filings. Is that correct?
Chair, Commissioner Bluestone, I don't have the number at hand, but it was in the 3 digits.
Okay, so it was over 100. And do we know how many people did file timely? I mean, if there were over 100 that were late, about how many were required to be filed and how many did actually file?
There's approximately 650 individuals under the statute who have to file, given the boards and commissions who have members subject to Senate confirmation.
So about 1/6 were late.
That's a fair estimate.
Okay. And of those 100 plus that were late, how many letters did our office send out to the people who you determined were the ones that should be the first wave of recipients of letters because of the positions they held in the State Investment Council or heads of agencies? About how many of those letters went out?
We're focused on about a dozen individuals.
Oh, only 12. And so, and it was only one or two of those that Casey said that filed right after that. But now, if she said about half have filed, so about 6 of those 12 have filed, is that correct?
Yeah, Commissioners Chair, Commissioner Bluestone, that's correct. It's, yeah. I think we've got about 5 outstanding right now.
With the caveat, Commissioner Bluestone, that we don't know. We're not in a position to know.
Right. And given these serious problems with the Secretary of State's system, I think you're right to be cautious in how you proceed and what you allege, and certainly before we're at a position of filing any lawsuits for late filings to require that they be submitted. But it also seems to me that one good option for you after your meeting with the Secretary of State's office is to issue the press release that we instructed and that you intend to issue at some point, and note the problems with the system, and just explain to the public, what is the serious problem. I mean, still 5/6, we're able to do it. 500 or so people did get it in on time, but it seems like one of the advantages of a press release is the public embarrassment that can help spur other people on who are simply delinquent to file properly. But I think that it's fair for us to also note the problems with that system and put the pressure out where it needs to be, as the chair said, to get that system fixed. But there's still the vast majority who were able to navigate it and get it in. And I think that we owe it to the public to let them know the status of the late filings and what we're doing about it and what our plan is for following up as soon as you deem that appropriate to issue.
Yes, Commissioner. Yeah.
I have a question. Does the Secretary of State offer any kind of assistance when somebody can't seem to figure out how to use this CFA system?
Chair, Commissioner Forkett, they do. They have a help desk line and an email address that they have sent to us, and they've asked that we provide that to individuals whose compliance we're trying to compel. I'm not quite sure beyond that how they're organized to respond to these issues.
Thank you.
Anyone else? Yes, Judy.
If I'm following this correctly, Jeremy, did you say there are roughly 650 individuals who should have filed? Is that correct?
No, ma'am. There are about 650 individuals, if you're not counting candidates, who have an annual obligation to file financial disclosures. So we're talking members of the legislature, state agency heads, the heads of the executive branches of government, the various constitutional executive agencies, and then any board member and commissioner whose appointment is subject to Senate confirmation. And when you tally all that up, it's approximately 650 folks.
Okay. One other question. So of those 650, you stated a number of individuals who filed, who did a timely submission. Can we be reasonably certain that those were even done correctly through the CFA system?
Our certainty that 5/6 filed is based on the Secretary of State's not referring them to us. We can go in and see who the filers are. I try to file early, being the director of the Ethics Commission, but this year Chief Justice Bacon beat me to it. I think that she filed on maybe just after midnight on January 1st of 2020. three. But so if you look and see who's filed, you'll see Chief Justice Bacon first, and then you can see a list of filers. And I haven't gone in to tally up how many people have filed.
See, do we have, does the commission have access to CFIS? Or are you relying on information that the SOS gives us?
Well, everyone has access to CFIS. We can pull it up and put it in the chat right now. It's a publicly available site.
Okay, very good. Thank you.
Thank you. Anyone else? Okay. Thank you, Jeremy. Thank you, Casey.
All right. Thank you,
At the
Commissioner.
risk of being wrong again, I'm going to ask that we move on to agenda item number 5, unless I am in derogation of the amended agenda.
You are not, Chair.
All right, go for it. This is advisory opinion number 2305.
So thanks, Chair and Commission. We have a pair of advisory opinions to present to you this morning. They both arose in the municipal context, and it's become apparent that we will continue to receive a lot of requests for advice from the local governments, and we welcome that. This began as a request for an informal advisory opinion, which we supplied, and Commissioner Baker asked that it be converted to a formal opinion, and that's what you have before you. The basic fact pattern in this first opinion is it relates to a very small municipality that owned a parcel of land, and at some point decades ago, an RV park began to operate near the parcel. Part of the backstory is the highway department at the time built some roads, and the municipality lost institutional memory that it owned the parcel, and the RV began to operate on the parcel. And that went on for many years. And at some point, an individual purchased the RV park, and then was elected as a trustee of the municipality. And after that individual was elected as a trustee, it became known to the municipality that it had this parcel and that the RV park was occupying it. And moreover, that one of the trustees owned the RV park. And so the lawyers for the municipality sent a request for what to do. The parcel was appraised at just over $5,000, and they wanted to know what was appropriate with respect to selling the parcel to the municipality, selling the parcel to the trustee, what law guided that transaction. And moreover, they asked whether or not the municipality had an obligation to try to recoup the funds, or to try to get a purchase price beyond the appraisal value, given the years that this trustee operated their RV park on the parcel. And so the advisory opinion is addressed to those questions. Under the Governmental Conduct Act, the provision that regulates transactions between a local government and an official of the local government, the local government official has to disclose their interest in the transaction, and the transaction has to follow a competitive process. And so the advisory opinion advises that the municipality can in fact sell the parcel to the trustee, so long as the trustee's interest is disclosed, and so long as it's advertised in an open and competitive way, such that other individuals could bid on the parcel of land. And then with respect to the amount of money that the village should pursue, that kind of takes the analysis into the anti-donation clause. The Governmental Conduct Act is really about the procedure that has to be in place with respect to transactions between a municipality and a local government official. The anti-donation clause goes to the substance of what a local government must or doesn't have to receive for property it owns. And the analysis advises that for years, the municipality has, unbeknownst to it, given a free leasehold of its property to a business in violation of the anti-donation clause. And that one way to remedy the violation is, in fact, for there to be a transaction where the municipality receives consideration in exchange for the parcel. And that could be both for the appraised value, and to the extent that there's an anti-donation clause issue kind of retrospectively, there could be consideration in a contract to the municipality to indemnify the municipality for the years that it owned the RV park. The trustee could give that to the municipality as consideration for the parcel. And the lawyers for the municipality finally asked, well, what do we do in the event that the negotiations with the trustee break down if they can't consummate a sale? And the advisory opinion advises that to remedy the anti-donation clause issue, the municipality should look at a civil action to retake and reclaim control over its property. And so, Chair and Commissioners, that in brief, not very brief, but in brief, is this advisory opinion, and I'd ask that you issue it.
All right, is there a motion and a second?
So moved.
Second.
Thank you. Any discussion? All right, hearing none, let the advisory opinion issue in 2023-05. Thank you, Jeremy. And on to your next.
Okay. Chair and Commissioners, this next advisory opinion is also one that arose in a municipal context. This relates to a former mayor of that municipality, who, when mayor, was briefed on and gave some direction to the municipality's negotiation team in the negotiations over a collective bargaining agreement with the Police Officers Association. That individual mayor has since left his position as mayor, and currently the Police Officers Association has reopened negotiations on its collective bargaining agreement. And that mayor is assisting and representing the Police Officers Association in the reopened collective bargaining agreement. And the request that came from the municipality's lawyer is whether, considering the mayor's former actions and current actions, whether or not the municipality can even enter into this agreement with the Police Officers Association. And so really it's a request for an interpretation and advice on the application of Section 8C2 of the Governmental Conduct Act that deals with contracts between local government agencies and individuals that are assisted in the transaction, or persons that are assisted in the transaction by former officials of that local government agency. And the way that analysis breaks down, there's kind of a couple of inquiries. The first goes to whether or not the local government official took an official act as a government official that in brief kind of feathered their nest, whether or not the contract at issue was a direct result of their official actions while in office. And the advisory opinion on those two prongs first advises that, yes, it's likely that the actions that the mayor took as mayor with respect to the collective bargaining agreement when he was on the municipality side were official actions, but that those actions weren't the kind of actions that were nest feathering types of actions. They didn't that if the city enters into a new collective bargaining agreement with the Police Officers Association, that contract is not a direct result from the official actions that the mayor took. In fact, the contract would be a result of many other actions, and the mayor's actions as mayor years ago are very attenuated to what's happening now. And so the advisory opinion advises that in fact, the municipality can enter into a renewed collective bargaining agreement with the Police Officers Association in spite of the mayor's actions years ago on a former collective bargaining agreement. So Chair and Commissioners, I hope that was intelligible. And I'd ask that you issue this advisory opinion.
Thank you. Is there a motion and a second?
So moved.
Second.
Thank you. Any discussion? All right, hearing none, the motion carries. Let the opinion issue. Thank you, Jeremy.
Thank you, Chair.
Okay, I'm gonna let you, well, next, Chair entertains a motion to go into executive session per applicable statute.
So
Is there a
moved.
motion?
Second.
Thank you. It's been moved and seconded. Any discussion? Hearing none, we are now moving into executive session. We'll take a second for the computer wizards to make that happen. Thank you.
Jeremy, are you setting up the breakout rooms, or do you want me to do that?
I'm doing it right now.
Right.
Okay, we are now in executive session, and let me. Stuart, are you with us?
I
You are.
am, but I
There
don't
you
know.
are. There you are.
Can you hear?
Yeah, you're good. Welcome back.
Thank
Okay, and boy, did you miss some discussion of Iceland and Brooke Shields. So we are back in the public meeting. Let me find my agenda.
Are we public yet?
Yes,
Okay, good.
we are, and we are on item number 10, authorization of civil actions. And Stuart, record will reflect that you are recused from voting in this matter. Right?
Yes.
So, Jeremy,
Casey, take it away.
or Casey.
Chair, Commissioners, I'm going to let Ms. Branch address this one.
Commission staff is seeking authorization of us to initiate a civil action regarding violations of the Governmental Conduct Act by a local public official.
Is there a motion, a second?
So moved.
Second.
Any discussion? All right, Commissioner Baker,
Yes.
Commissioner Bluestone is recused. Commissioner Castillo,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva,
Yes.
and the chair votes yes. Motion carries. Let the action be pursued. Item number 11. We're off. I'm sorry, that's off the agenda per the amendment of the agenda. Those items in the number 12. Casey?
All right, thank you, Mr. Chair. Chair, Commissioners, the Commission staff is seeking a motion to dismiss administrative complaint number 2023-006 for lack of jurisdiction. And I believe that Commissioner Bluestone is recusing from this matter.
He is. And is there a motion, a second?
So moved.
Or second.
Thank you. It's been moved and seconded. Is there any discussion? Hearing none. Commissioner Baker,
Yes.
Commissioner Castillo,
Yes.
Mr. Solomon,
Yes.
Commissioner Villanueva,
Yes.
And the chair votes yes. The matter will be dismissed. Next item.
All right, Chair, Commissioners, Commission staff is seeking a motion to dismiss administrative complaint number 2023-019 for lack of jurisdiction.
Is there a motion and a second?
So move.
Second,
Thank you. Moved and seconded. Any discussion? Hearing none. Commissioner Baker,
yes.
Commissioner Bluestone,
Yes.
Commissioner Castillo,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva,
Yes,
and the chair votes yes. Motion carries. Item will be dismissed. Next.
All right, the commission staff is seeking a motion to dismiss administrative complaint number 2023-021 for lack of jurisdiction.
Thank you. And is there a motion and a second?
So moved.
Second.
And any discussion? Hearing none. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Solomon.
Yes.
I'm sorry, Commissioner Castillo,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva,
yes,
and the chair votes yes. Motion carries.
All right, the remaining item, commission staff is seeking a motion to dismiss administrative complaint number 2023-024 for lack of jurisdiction.
Is there a motion and a second?
So move.
Thank you. There's a motion and a second. Any discussion? Hearing none. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Castillo,
Yes.
Mr. Solomon,
Yes.
Commissioner Villanueva,
yes.
and the chair votes yes. Dismissed. Thank you, Casey. Next.
Okay, Chair, this next matter relates to a pro bono representation that I would like to undertake. There's no direct conflict of interest, and so under the rules of professional conduct, I don't think I need written consent. And because it's pro bono under the Governmental Conduct Act, it's not something that I have to disclose. But despite those two rules, it's something I wanted to discuss with you and ask for your blessing on. This relates to the redistricting. As you know, for a few years, I've done pro bono work related to redistricting reform. That started years ago when I was on the task force that New Mexico First convened, that was chaired by Justice Chavez and Judge Kennedy, that led to the Redistricting Act, a bill that Justice Chavez and I largely drafted before it was introduced. And as you know, I've also helped Representative Figueroa in drafting a constitutional amendment to create an independent redistricting commission. Recently, I've been asked to represent certain amici in the redistricting case. That case is pending in the 5th Judicial District. All of the judges in the 5th recused, so it's being handled by a judge from Clovis, Judge Van Solen. There was very significant briefing and a very, very significant decision by the New Mexico Supreme Court in this matter, that in New Mexico, state equal protection challenges to redistricting maps, unlike in federal court, do not present a political question, that they are in fact justiciable, and that the New Mexico courts are capable to decide equal protection challenges to redistricting maps. And that's a hugely significant decision that the Supreme Court has taken, because they have broken from what the United States Supreme Court did in the case Common Cause versus Rucho, where the US Supreme Court held that constitutional challenges under the federal constitution to state districting plans for partisan gerrymandering are non-justiciable political questions. But in that opinion, Justice Roberts left it open that in state courts, state constitutional challenges, whether or not those are justiciable is a matter for each state Supreme Court. And our state Supreme Court adopted the test that Justice Kagan outlined in her dissent in the Rucho case, in the test that she gave for how she thought equal protection challenges should be adjudicated. Justice Kagan's dissent was very much built on the presence of quantitative analyses in this field. And in the analysis of redistricting maps in the past decade, there has been an enormous amount of work, mainly by academics and legal academics and mathematicians, on how to evaluate redistricting maps and test them as potential maps that are outliers as compared to a huge ensemble of maps that these mathematicians use computer algorithms to create. And that kind of quantitative analysis was very much part of the Rucho record. Some of you know that Rucho was a case that was argued by my former boss, Emmett Bondurant, in Atlanta, and I was in the Supreme Court the day Rucho was argued. It was a matter that when it was in the district court before I left the firm, I had some minor involvement in. So Justice Kagan's dissent, the test that she outlined for how to evaluate equal protection challenges under certain evidence to districting maps for partisan gerrymandering, is very much built on this kind of quantitative analysis, these ensemble maps. And recently I've been approached initially by Heather Ballas, who is at the Election Reformers Network, a group out of DC, to help be part of the representation for a team of amici to present an amicus brief in support of neither party in the redistricting matter that's pending in the Fifth. The main amicus is a gentleman whose name is Dr. Samuel Wong. Samuel Wong is a neuroscientist at Princeton. He's a mathematician. He's the head of Princeton's Election Innovation Lab. And he and another statistician at Princeton, whose name is Jonathan Service, are the main amici. And right now in Princeton, they're creating these ensemble analyses for New Mexico's congressional map, where they're building thousands, tens of thousands of computer-generated redistricting plans, and they're comparing the map that the legislature drew as compared to that large ensemble of computer-generated maps across many different metrics, many different tests for thinking about whether or not a redistricting plan is an extreme partisan gerrymander. And so they're the main amici, but there are also other amici, to include the Election Reformers Network and the Campaign Legal Center, a group in DC that we do work with here at the Ethics Commission. And they've asked me to be part of the lawyer team to craft this amicus brief, the motion for leave to participate as amicus, and to present it to the district court. And if there's an appeal ultimately to the Supreme Court. It's something that I would like to do, because following the docket in this case, it doesn't appear that the parties are going to present the court with this view into how Justice Kagan's dissent ought to be applied, how the test that she outlined, and that's the law that the Supreme Court instructed the court to follow, Judge Van Soelen to follow. It doesn't seem as though the parties have retained experts to produce ensemble type analyses. Judging from the docket filings yesterday and the Republicans' witness list, the plaintiffs in this case it doesn't appear that they have an expert that's really capable of the kind of ensemble analyses that these mathematicians are producing. And I'm not sure that from the conversations I've had with the lawyers for the legislative defendants, that's part of their plan either. And so, but I think that in order to really evaluate equal protection challenges under Justice Kagan's dissent, which was built on having this kind of analysis available to the court in Rucho, that it would benefit the adjudication of this case for the New Mexico courts to have insight into this type of ensemble type quantitative analysis of the map. And it's something that I think I could help the team of lawyers, including a lawyer from the Campaign Legal Center and a lawyer from Election Reformers Network, to communicate to our courts, our state courts, and to help our state courts adjudicate these kinds of claims, since this is the first time in which the court's called to do so. And so with that, I'm asking for your permission to allow me to join in on the amicus team. So Chair and Commissioners, that's my little presentation on what I've been asked. And as I said, I'm willing and would be very pleased to be part of that effort.
All right, thank you. Anyone have any questions or offerings on this?
Yeah, I have a question.
Sure.
What's your guess, Jeremy, with this quantitative analysis? Is it likely to be helpful to the legislature's position, or is it likely to be helpful to the other side?
I don't know, Commissioner Baker. I haven't seen the graphical presentation of the analysis yet. And I do know that the amici are not interested in presenting the court with a conclusion as to whether or not the map that the legislature enacted is or is not a gerrymander that runs afoul of the Equal Protection Clause. The most that the lawyer team wants to do and the amici want to do is present the court with the quantitative analysis as applied to these maps, what it is, and then enlighten the court on what other state Supreme Courts or other state courts, other special masters have concluded on analogous plans. Part of presenting this kind of analysis requires a judgment call as to what in fact is an extreme outlier. And that's also a determination that the statisticians, the mathematical team, is one that they would need to make. And I'm not even certain that they're going to make a suggestion as to that, as opposed to just pointing out in other cases, courts have said 2 standard deviations from the mean on these metrics is an extreme outlier, or whatever they might say. But the short answer is I don't know, and it also requires a kind of judgment call if in fact the legislature's map is on the border area of what is very much an outlier in a kind of bell curve type analysis. I don't know what the Princeton mathematicians are likely to say is whether or not that's in fact a large outlier or not. So the short answer is I don't know who it's going to benefit.
Well, hypothetically, and this is maybe I'm getting way off into the ozone, but if Judge Van Solen were to say that the map which the legislature adopted was violated equal protection, does the case then go straight to the Supreme Court, or does it go to the Court of Appeals first?
I believe the appellate review for challenges to redistricting maps is direct to the Supreme Court.
Okay. And if the Supreme Court were to say that the map which the legislature used was invalid, then presumably the Supreme Court would tell the legislature start again?
I don't know.
Committee?
That's a possible remedy. The appointment of a special master is another possible remedy. There's different ways that could go.
All right, and I don't know the universe of folks who are for rent to do this kind of work, but the folks who have approached you, would they be possible vendors if this redistricting has to go back to square one?
Vendors to the state?
Yes.
No, sir.
Okay, I'm just trying to think of reasons why your participation might be bad for the Ethics Commission. Obviously, you're interested in doing it. You have a lot of you have relationships with people who do this kind of work. You were very involved in what we tried to do earlier with Justice Chavez and Judge Kennedy. And so I want to say yes, but I also want to protect the Ethics Commission, and I'm interested in exploring what some of the pitfalls might be.
All right,
So,
thank you. We'll go in order. Commissioner Bluestone?
Thank you. Jeremy, as I understand it, you're saying that you don't believe you are required to ask the commission for approval, but you want to as a courtesy. And I assume then you're asking to do this as Jeremy Ferris, attorney at law, rather than Jeremy Ferris, executive director of the State Ethics Commission, or am I misunderstanding that?
No, Commissioner Bluestone, you're understanding it correctly. If my name were on the pleading, it would be Jeremy Ferris, and then with the address that the bar has for me, which is my home address, and with my Gmail account as my email. I might need to make some changes on my electronic filing in order to file in a way that it goes to my Gmail account, but I'm sure I can do that.
Well, I thank you for that clarification, and I commend you for wanting to give of your own time and effort on an issue that I know you care deeply about, and I'm sure you would be able to add considerably to the court's knowledge of the issues. And I thank you for the courtesy of telling us about it, and I would be wholly in favor of supporting you, particularly since we don't even know what the side is that the result of the analysis will be supporting. You're providing technical expertise and guidance to the court and to our system, and I think that's to be respected and admired. And I thank you for your willingness to do the work, and I'm happy to give you the blessing you're asking for. And thank you for coming forward.
Thank you. Celia?
I don't have any questions.
Thank you. How about you, Ron?
I thank you, Jeremy. You know, this is I think as Stuart described it, it's a very noble and probably for you a very interesting task to undertake. And I have a couple of just practical questions, you know, relative to the role that you have now for the commission. You know, we have to ask, I think, this question, which is, do you think you have the time? Because I imagine it would require, you know, some of your daily time and then probably a lot of your weekend time as well. You know, how will that impact the commission and your role with the commission? Will you have to delegate any of your authority to anyone? And then second, how is this going to be compensated to any of you that are going to participate in this effort as amici or amici. Third, just kind of a curious question on my part in terms of the team that you described. I know probably largely attorneys, but are there others that are going to be behind this effort? I know you mentioned Heather, whom I believe you know, that I know, I've served on the New Mexico First Board when this was being sort of developed back in the past. So just hearing her name, of course, that reminds me of that effort back when. So those are my questions, Jeremy. I won't prolong this.
Thank you, Commissioner Solomon. So Commissioners and Commissioner Solomon, it wouldn't detract from my duties at the Ethics Commission. The lawyers that are representing the amici intend to write this brief over the weekend and file it early next week. Under the scheduling order, the briefing for briefs addressed to justiciability and standing, if there are any, is due, I believe, on August the 10th. And that's when this team is intending to file. The litigation in the district court is extremely accelerated. The Supreme Court gave the district court an extraordinarily accelerated timeline. And I think the trial is in end of September, I believe. And so there's the amici want to file this really as soon as possible, to give the court a sense of it, but also to give the parties for both sides the opportunity to question the Princeton experts if that's something that they would like to do. And so the idea would be to file very soon, which means that it would be my weekend. But beyond that, I don't think there would be much else in terms of pressures on my time with respect to the commission. And I am very much not in the first chair on this. There are two lawyers, one at Election Reformers Network and the other at the Campaign Legal Center, who know this area of law better than I do. And my role is just to kind of help them to the extent I can and help them navigate state law in New Mexico and the New Mexico cases that are helpful, and just to also guide them through the local rules that we have in New Mexico court. And so I'm not in any way the primary lawyer on this matter, and I shouldn't be. These two gentlemen, they know what they're talking about. The amici, the main ones are, as I said, Samuel Long and Jonathan Servos at Princeton. They're both academics at Princeton. There's a gentleman named Paul Mitchell who has a firm in California called Redistricting Partners. He's also an expert and has advised the California Redistricting Commission on its work. And the major national kind of good government organizations are, as I said, Campaign Legal Center and Election Reformers Network, whose lawyers are prime. And then I imagine that when the brief is prepared, there will be organizations that are part of New Mexico's Fair Districts New Mexico coalition, of which the League of Women Voters is first and foremost, that will sign on to this amicus. But the number of New Mexico kind of good government organizations that will sign on to the mathematician's brief, that kind of remains to be seen. So that's kind of what the team is, as it were. And I'm very, very confident that I can do this without it detracting from my responsibilities here.
Okay, thank you very much.
Thank you. Commissioner Judy?
I don't have any questions, but I do have a couple of comments.
Yep.
Jeremy, I feel like I'm in the presence of extraordinary talent, and I think you should be honored to have been asked to participate on this team that to write this amicus brief. I appreciate you coming to the commission, even though I don't believe you had to. And I also believe that if you thought in any way there would be any detriment, your participation would have any detriment on the commission, be it your use of time or on its reputation, that you wouldn't be here today asking us. So you asked initially for a blessing, and you have mine.
Thank you for
Okay.
being away. But while I don't think this will have any blowback on the commission, redistricting is very fraught, and that's true. But being the director of the Ethics Commission is also very fraught. And the, and I just I kind of see the two in the same. They're things that we've done here has caused people in the legislature to be upset with me, and that might be the case with this matter too. But part of this discussion is to separate the Ethics Commission from that, and that goes to Commissioner Bluestone's point that I won't be I'm just a lawyer in this matter. We're apart from my day job.
Thank you. And just so you know, I mean, I have the same sentiments and thoughts about Jeremy's good work in offices as the rest of you. It's just, I get to probably meet with them more than the rest of you because of my duties as chair, and I have the highest regard for his work, his ethics, and his ability to obey and stay in all of the right lanes. My one concern, and I've expressed this to him, is not his bona fides, but those of folks who may feel wronged by whatever ultimate decision is made by the state Supreme Court. And at some point down the road where the Ethics Commission and its executive director in the form of Jeremy surface and rightly or wrongly, and I would say wrongly, because these are the times we live in, somebody will point to a position, again, accuracy doesn't have any part of this, but well, the Ethics Commission played a role, he did this, that team won, therefore I'm on the other team. He and thus the Ethics Commission is tainted and can't hear my case. I have little to no confidence that those folks aren't out there carrying the day in all media outlets every day. And I'm not limiting it to one side politically. Those are my concerns, and it's a real concern, and it has to do with what may happen down the road, not with the legitimacy of what Jeremy's pursuits are or what I may believe in it. I think he's perfectly okay to do it. I think he didn't have to ask us, so it doesn't matter what I think. I am concerned about the long-term ramifications of anybody trying to make the argument down the road, well, I was acting in my capacity as an individual lawyer and not as a functionary or an employee of the Ethics Commission. As legal and as legit as all of that is, that doesn't mean it will carry the day. So I've said that piece. I've shared that with Jeremy. This is not new to him. It has nothing to do with my thoughts about him. I want to make clear that that's something, that's a little bit of heartburn that I have over this engagement. But as you correctly point out, Jeremy, and I agree with you, you don't need our permission. But there's certainly not been anybody who has thrown up a block to you doing it. Godspeed, and I hope your weekend is as enjoyable as mine.
Well, let me ask you a question about that. I mean, Jeremy, would you like a motion approved to grant your request for your personal participation in this case, or are you comfortable just having had the discussion here in open session?
I'm comfortable. It's on the agenda, and this has been recorded. We can point back to it if we ever need to.
Okay.
The only
Thanks.
thing I would add
Okay.
is that to the extent that anybody cares, what I understand Jeremy to be doing is to be providing technical assistance to the court or courts plural. And I think that's appropriate and presumably will be helpful to the decision makers.
All right, thank you. The next meeting, which is going to be a bit of a moving target here, at least for now, because we have some schedules to deal with. Jeremy, you want to put us all in one place?
Thank you, Chair. So the next normally scheduled meeting would be the first Friday of October, but because of commissioner unavailability, we won't have a quorum for October the 6th. And so I've asked Commissioner McMillan for his availabilities in late September and October, and he is available for a meeting on October 20th or the 27th. And that's what I have regarding the absent commissioner. And with that, Chair, I just asked the commission to try to find a date, and we'll make the meeting logistics work for whatever you decide.
Thanks. Is the 20th okay?
Can I have 30 seconds?
Yeah. Stuart, you were going to be gone in October, right? But I think the 20th was outside of your.
Yeah, it's a day outside of when I expect to arrive, but just because it's international travel, I would prefer to do the 27th if that's as viable an option as the 20th. If the 20th is the preferred date, I'll do my best to be there, and I think it will work, but I always get nervous about international travel.
Yeah. No, the airlines being what they are and whatever. So the 27th, everybody okay with the 27th?
Chair.
Yeah, I'm not, but don't hold it up because of me.
Ron.
Okay, Chair, thank you. The 27th, I'll just be returning from Papua New Guinea, and that's all. I'm going to be. I think it's losing a day or something like that. But
so you don't really.
Yeah, I'm going to be in rugged shape then too. So I just won't be able to do it. But the 20th, I mean, that whole week I will be gone, 23rd through the 27th, and then the prior week, the 20th, that's okay with me, or a day earlier is okay with me as well.
But then let's go for the 20th if that works, because I should be able to do it, and if I can't, so be it. But hearing what Ron's saying, I think the 20th is probably the better option of the 20th and 27th. Jeff, did you say you could not do the 27th, but you could do the 20th?
No, I cannot do either one, but that's okay.
Well, it's not. I just assume not go forward with missing two commissioners. I don't want to set that.
Oh, I'm sorry. The 27th is hard for me. The 20th would be okay. The 27th out for me.
Right. Okay. So we can't do the 20th or the 27th. What's the next Friday? What's November's first Friday?
Friday, November the 3rd.
Everybody okay with that?
I can do it.
I can do it.
Do we know about Dr. McMillan?
We don't, but if everyone on this call can make it, then we have a quorum for the 3rd, and it's a lot of notice. So
it is a lot of notice. Yeah. Okay. Let's go ahead and set the meeting for November 3rd.
If I might, if Dr. McMillan can make it, I think it might be a good idea to try to have a meeting in person so that everybody can meet him.
We discussed that, and that was such a wretched bomb the last time we did it up in Santa Fe, thinking everybody would be glad to see us, and we went to all the trouble and nobody showed up except 2 or 3 non-commission members or staff. But that's something that is certainly discussable, and hopefully I will have a chance to talk to him to maybe we can do some sort of hybrid. I mean, if that's the sole reason, maybe Judy doesn't want to schlep all the way to up here. being Albuquerque or Santa Fe from Carlsbad, but yeah, that's a discussable point, I think. So so the next meeting will be November 3rd. Place TBD, but for now online. And if there's something that requires the commission's attention, either by way of its import or some sort of vote, we will send out a notice of a special meeting and an agenda therefore in concert with all of the appropriate rules, regulations, and laws. And that leaves the next item, which is public comment. Walker, I'm assuming you're still the gatekeeper on that.
Yeah, it looks like we've only got one member of the public here, gentleman named Rich. And Rich, go ahead and raise your hand if you're interested in making public comment. Otherwise, I think we can move to closing the meeting.
Mr. Rich, I've known you've been a very loyal member of the public attending these meetings, and we'd be delighted to know who you are if you'd like to make public comment.
No response.
Okay. All right. Thank you. Thanks for your good offices, everybody. Nice to see everyone. And hopefully November 3rd or before, we'll see you then. Everybody take care. Meeting's adjourned.
Goodbye,
Thank
everyone.
you.
Thank you.
Bye-bye.
Bye-bye.
Bye.